Hi, good morning, everyone. My name is Russell Cooper, and today we'll be discussing how to maximize data protection compliance in Jamaica, the advantages of the GDPR training. This webinar is brought to you by PECB in collaboration with CyberScience Technologies. And just a little about the organizations. So PECB, which is the Professional Evaluation and Certification Board, is a certification body based in Montreal, Canada, and they specialize in providing education and certification services in various disciplines. And they operate under the ISO IEC 17024 standard, ensuring the competence and impartiality of the certification process. So their role is really in global and regional compliance and training. PECB offers a wide range of certification programs. They offer accreditation and recognition. They have a global reach. They have a comprehensive training courses, over 200 training courses delivered through various formats, including classroom, live online, e-learning, and self-study options. This flexibility really enables learners to choose the most suitable learning method based on their preferences and needs. They also have a wide range of expertise and support with over 1,800 certified trainers and collaborations with over 2,000 organizations. And PECB really maintains a consistent quality in terms of its standards across the training and certification programs, which ensures that participants receive relevant and up-to-date knowledge and skills as it relates to their training courses. So overall, PECB plays a crucial role in promoting and enhancing compliance training on a global scale. A little about CyberScience. CyberScience is a technology startup in Jamaica that specializes in cybersecurity solutions, specifically as it relates to data protection and compliance, as well as other solutions that persons can use or companies can use to have a more robust system in place. Now, getting that out the way, we can go ahead and start discussing, data protection and privacy in today's landscape and the importance of data protection and privacy. Now, we know that data protection and privacy is really crucial in today's age for several reasons, particularly because individuals entrust various organizations with their personal information, including sensitive data, such as financial details, medical records, and contact information. And data protection ensures that this information is safeguarded against unauthorized access, misuse, or exploitation. We also know that organizations that prioritize data protection and privacy really build trust with their customers. When individuals feel confident that their data is being handled responsibly, they are more likely to engage with businesses and share information. So conversely, data breaches or privacy violations can severely damage an organization's reputation and erode trust. We also have the legal compliance aspect of data protection, and we know that in many countries, they have enacted data protection laws and regulations, such as the GDPR, which we'll be discussing today, and the Jamaican Data Protection Act, which we will also be discussing today. So just as an overview of why data protection is important in today's society, data protection and privacy, they're really fundamental principles in the digital age. They promote trust, transparency, and responsible data stewardship while safeguarding individuals' rights and interests in really what is an increasingly interconnected world. So it's a really important thing, data protection and privacy, that companies really need to focus on and pay attention to. And that this webinar will help companies to see the importance of and see how they can implement a system or a strategy whereby they remain compliant with data protection laws and regulations. Moving on from that, we can discuss Jamaica's Data Protection Act and understanding it, understanding how the Jamaica Data Protection Act interplays with companies and individuals. So to start off that aspect of the discussion, we will really have to look at some definitions that are important. And some of these definitions you will hear throughout the webinar, as they are really crucial to understanding how data protection works. So the first definition we look at is personal data, right? And this is defined as information, however stored, relating to a living individual or an individual who has been deceased for less than 30 years, who can be identified from that information alone, or from that information and other information in the possession or likely to come into the possession of the data controller, and includes any expression of opinion about that individual and any indication of intentions of the data controller or any other person in respect of that individual. So that's a long definition. What it really is is any information that a person can be identified from. And a key point of the definition to note is that this information or this individual can be deceased for up to 30 years, and that information will still be considered personal data. So this is an important section of the legislation that appears in the Data Protection Act, which data controllers really have to pay attention to, as it is not just individuals who are living, but those who are dead up to 30 years that personal data relates to. So moving on from personal data, we can define processing. So the term processing really means, under the Act, at a very basic level, obtaining, recording, or storing the information or personal data, or carrying out any operation or set of operations, whether or not by automated means, on the information or data. So this can include organization, adaptation or alteration of the information or data, retrieving, consulting, or using the information or data, disclosing the information or data by transmitting, disseminating, or otherwise making available the information or data, or aligning, combining, blocking, erasing, or destroying the information or data, or rendering the data anonymous. So processing really means most processes or most things you can do with data. So if you receive the data, if it goes into your computer, if you put it in a database, if you transfer it, if you send it, all of that can be regarded as processing the data. Now, the next definition we can look at is data controller. And a data controller can be defined as any person or public authority who, either alone or jointly or in common with other persons, determines the purposes for which and the manner in which any personal data are to be processed, and where personal data are processed only for the purposes for which they are required under any enactment to be processed. Now, the person on whom the obligation to process the personal data is imposed by or under that enactment is, for the purposes of the Act, a data controller. So a data controller is essentially someone or a public authority or a company or a body who processes personal data, and we defined processing just a while ago. So you can apply that definition to a data controller. Now, a data subject is the next term that we'll define. And a data subject means a named or otherwise identifiable individual who is the subject of personal data. And in determining whether an individual is identifiable, account shall be taken of all means used or reasonably likely to be used by the data controller or any other person to identify the individual, such as reference to an identification number or other identifying characteristics, whether physical, social, or otherwise. So a data subject is a person whose personal data is being processed by the data controller. So that's a sentence in which all the definitions can be used. And the final definition that we look at today is consent. Now, consent is not specifically defined in the Jamaica Data Protection Act. However, it is defined in the GDPR, and it's defined as any freely given, specific, informed, and unambiguous indication of the data subject's wishes, by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data related to him or her. So that definition is a general definition that we will use for consent, as it is defined as such in the GDPR, and we can look to GDPR as a sort of precedent to define some of these terms. So now that we've defined these terms, we can look at the data protection standards. And both the Jamaica Data Protection Act and the GDPR centers mainly around processing data in accordance with specific data protection standards. Section 21.1 and 21.2 of the Jamaica Data Protection Act puts an obligation on data controllers to process personal data in relation or in accordance to these standards. The standards are these. The first one is fair and lawful processing. The second one is a purpose limitation. The third one is data minimization. The fourth one is accuracy. The fifth one is storage limitation. The sixth one is compliance. The seventh one is security. And the eighth one is data transfer. Now we'll go through these step by step and define what the standards really mean. But just as our host really requires a solid foundation and pillars to be strong, compliance with the Act steadfastly rests on these principles. So let's discuss what they mean. As it relates to fair and lawful processing, under the Act, this standard really indicates that personal data should not be processed unless A, consent is obtained from the data subject, B, the processing is necessary for the performance of a contract with the data subject or for taking steps at the request of the data subject with a view to entering into a contract. C, the processing is necessary for compliance with legal obligations, whereas the data controller is subject other than a contractual obligation. D, the processing is necessary in order to protect the vital interests of the data subject. E, the processing is necessary for the administration of justice or for the exercise of any functions conferred by or under any enactment or for the exercise of any functions of a public nature exercised in the public interest. Or F, the processing is necessary for the legitimate interest pursued by the data controller or by any third party to whom the data are disclosed, except when the processing is unwarranted in any particular case by reason of prejudice to the rights and freedoms of legitimate interest of the data subject. So the main underpinning of the fair and lawful standard is really the requirement for consent. So without consent, the processing of personal data would need to be necessary for one of the above mentioned purposes. So that is the reason why we had to define consent at the outset, so that we can understand exactly what it means to get consent from data subjects. So that would be the fair and lawful processing standard, the first one. As it relates to the second one, which is purpose limitation, this really means that personal data must be collected or obtained for one or more specified and lawful purposes and cannot be further processed in a manner which is not in line with those purposes. Data minimization, which is the third one, essentially means that personal data which is collected must be adequate, relevant, and limited to what is necessary for the purposes for which they are processed. So data controllers should really refrain from collecting more data than they actually need. Accuracy, as the word implies, means that the data must be accurate and kept up to date where necessary. So data controllers must pay keen attention to how accurate the data they collect is. Storage limitation means that personal data should not be kept for longer than is necessary for the purpose of processing. So personal data should only be disposed of in accordance with the regulations under the legislation. So data controllers should not house data for an extended period of time, more longer than they actually need the data. They should seek to dispose of the data as soon as the need passes, and that disposal should be in accordance with the regulations under the Act. Compliance simply means that personal data should be processed in accordance with the rights of data subjects under the legislation. And this standard really seeks to ensure that data controllers comply with the various obligations under the Data Protection Act. And the seventh standard, we call it the security standard, and it really ensures that the appropriate technical and organizational measures are taken to prevent unauthorized or unlawful processing of personal data. And it serves to protect against accidental loss or destruction or damage to personal data. So the Act really indicates that the measures implemented should ensure a level of security appropriate to the nature of data being protected and the harm which may result from accidental loss, destruction, or damage. So certain kinds of data might require a higher level of security or more measures in place to protect against that accidental loss, damage, or destruction. And finally, the eighth standard has to do with data transfer. And this means that personal data should not be transferred to a state or territory or country outside of Jamaica unless that state ensures an adequate level of protection for the rights and freedoms of data subjects. So those are the 8 data protection standards by which data controllers must oblige themselves, must operate under. Now we can move on to some of the obligations of data controllers under the Act, and they really should process data in accordance with all 8 standards, but their responsibility goes a little beyond that. You know, some of the more important obligations under the Jamaica Data Protection Act include the obligation to report data breaches to the regulator within 72 hours of the breach. So whenever or if there happens to be a data breach, the data controller has the obligation to report that breach to the Office of the Information Commissioner within 72 hours of that breach. They also have the obligation to notify the data subject of that breach or of any contravention to the data protection standards. Another important obligation they have is to register with the Office of the Information Commissioner, as well as to produce or prepare a data protection impact assessment. Now that DPIA, what we call it, will assist data controllers to see how their data is being processed and where gaps might be or gaps may be in the processing, so that they can address those gaps and be in compliance. And the fifth important obligation of a data controller is to appoint a data protection officer. Let's consider the rights of data subjects under the Jamaica Data Protection Act. So data controllers must keep the rights of data subjects in mind when carrying out their obligations. And the legislation specifically affords certain rights to these data subjects. Some of the more important ones include the right of access, which is brought out in Section 6 of the legislation. This involves the data subject being entitled upon making a written request to a data controller to be informed by the data controller, free of charge, whether his personal data is being processed by or on behalf of the controller, and to provide a description of the personal data, the purposes of processing, and the recipients or classes of recipients to whom they are or may be disclosed. So they have a right to ask the data controller about their data, how much of the data is being processed, how it is being processed, and who it is being disclosed to, if anyone. Data subjects also have the right to rectification. So they may request that a data controller rectify any inaccuracy in any personal data in the possession of a data controller and of which the individual is a data subject. So if your name is spelled incorrectly or if your TRN is inaccurate, you have the right to have that rectified as a data subject. Data subjects also have the right to prevent processing for a number of reasons. They may request that the data controller cease or not begin processing of personal data if the processing of the data for that purpose is causing or likely to cause substantial damage or distress to the data subject or to another, and that the damage or distress is unwarranted. So they have a right to prevent processing likely to cause damage or distress, and that is borne out in section 11 of the legislation. They also have the right to prevent automated decision making as it relates to their data. So individuals are entitled to object to systems of automated decision making where the automation was the sole basis of the decision making for matters relating to the data subject. So that's another right that they have. Some of these rights, as you will see, are mirrored in the GDPR when we start discussing that. So after discussing those rights, we can look at some penalties as it relates to breaches of the legislation. So section 61 to 69 of the Jamaica Data Protection Act really outlines for us some of the penalties that data controllers can face if they breach the act. So one penalty that they can face is fines from the Office of the Information Commissioner for breach of the act. And these fines can be for the company as well as directors or senior officers or secretaries of the company. And the fine is not exceeding 4% of annual gross worldwide turnover if the company commits an offense under the act. So fines fines is one aspect or one penalty under the act. Another penalty is, of course, civil liability for breach of the act. So individuals or data subjects can commence litigation or sue companies who breach the act. So if they suffer harm or loss as a result of a contravention by data controller of its obligations under the act, then they may have a cause of action and be entitled to compensation. So data controllers really need to look out for individuals or look out for or ensure that they don't breach the legislation so that they don't open themselves up to liability and litigation. And then companies can face criminal liability for breaches of specific sections of the act. So data controllers may face fines as well as imprisonment for certain breaches of sections of the act, and that is borne out, as I said, in section 61 to 69 of the act. Now we can move on to discussing the GDPR, which is really a benchmark for global data protection. And just a brief history of the GDPR, which means the General Data Protection Regulation. We know that the GDPR really represents a significant milestone in the evolution of data protection laws in Europe, and it's really aimed at strengthening and unifying data protection for individuals within the EU and the European Economic Area. So before the GDPR, the primary legal framework governing data protection in the EU was the Data Protection Directive, which is the Directive 95/46/EC, and that was adopted in 1995. And then the GDPR 2016/679 came into force in May 2018, and it really focused on addressing the transfer of personal data outside of the EU and EEA areas, while strengthening the definition of consent for processing personal data and other aspects of the legislation that was deficient from before. Some of the key features of the GDPR include, as I mentioned just now, strengthened consent. So consent for data processing must be freely given, specific, informed, and unambiguous. That is the definition of consent that we discussed earlier. That is, that we're discussing again now. The right to access also exists in the GDPR, which indicates that individuals have the right to know what personal data is being processed and why. The right to be forgotten is also a key feature of the GDPR. This is also really known as as data erasure, which allows individuals to have their data deleted under certain conditions. Data portability is another thing that is very key to the GDPR, which means that individuals can request that their data be put in a format that allows for easy transfer between service providers. So that is what data portability means. Of course, the GDPR also has a requirement for organizations that process a large amount of personal data to appoint a DPO. There's also a breach notification requirement, mandatory reporting of data breaches likely to pose a risk to individuals, and that must be done within 72 hours, just like our Act. And there's also penalties under the GDPR, which includes fines as well. So these key features of the GDPR are just some of them. We can't address all of them today, of course. But what we'll do now is have a comprehensive analysis between some of the key features of the GDPR and some of the key features of the Jamaica Data Protection Act, particularly as it relates to the rights of individuals and the obligations of data controllers. So we'll start up with the rights of data subjects. And as we know, as we just discussed, that the right of access is one that is present in both sets of legislation. So you can find the right of access in the GDPR as well as the Jamaica Data Protection Act. And they look relatively similar in how they operate under the legislation. The right of rectification is also one that exists both in the Jamaica Data Protection Act and the GDPR. The right to erasure is one that exists only in the GDPR and not in the Jamaica Data Protection Act. So you will not find that right under the Jamaica Data Protection Act. Now, the right to object or the right to prevent processing is one that is found in the GDPR as well as the Jamaica Data Protection Act. Now, what you have to consider as it relates to the right to object is that under the GDPR, the specific data subject right is listed or indicated as the right to object, not the right to prevent processing, versus in the Jamaica Data Protection Act, it is listed as the right to prevent processing, but they amount to essentially the same thing in terms of how they operate with data subjects. Now, the right to restrict processing is one that exists in the GDPR, but one that does not exist with the Jamaica Data Protection Act. And there is a difference between the right to restrict processing and the right to object to processing. The right of data portability is one that exists in the GDPR, but one that does not exist in the Jamaica Data Protection Act. And also, the right to prevent automated decision-making is one that exists both in the GDPR and in the Jamaica Data Protection Act. So we have a number of rights that are listed in the Jamaica Data Protection Act that are not listed. Sorry, we have a number of rights that are listed in the GDPR that are not listed in the Jamaica Data Protection Act. So the expanse of protection is wider as it relates to the GDPR than the GDPR. So data controllers should keep that in mind when looking at the rights of data subjects. Now, as it relates to the obligations of data controllers, we have a number of obligations that exist in the GDPR which don't exist in the Jamaica Data Protection Act. And we can start out with the obligation to appoint a data protection officer. Now, this exists in both legislations. However, under the GDPR, data controllers should appoint a DPO in any case where the processing is carried out by a public authority or body, except for courts acting in their judiciary capacity, or the core activities of the controller or the processor consist of processing operations which, by virtue of their nature, their scope, and or their purpose, require regular and systematic monitoring of data subjects on a large scale, or the core activities of the controller or the processor consist of processing on a large scale of special categories of data pursuant to Article 9 and personal data relating to criminal convictions and offenses referred to in Article 10. Whereas under the Jamaica Data Protection Act, data controllers are required to appoint a DPO in cases where they are a public authority, they process or intended to process sensitive personal data or data relating to criminal convictions, processes if the data controller processes personal data on a large scale, or falls within a class prescribed by the Information Commissioner. So very similar requirements to appoint a DPO, just very slight wording, but mostly if you stick to the GDPR's requirement to appoint a data protection officer, you will in most cases cover the Jamaica Data Protection Act's requirements to appoint a data protection officer. Now, another obligation under the GDPR is security of processing. Now, the GDPR lists security of processing specifically as a duty of the data controller and indicates that data controllers must implement appropriate technical and organizational measures to ensure a level of security which is appropriate to the risk. Now, the Jamaica Data Protection Act does not specifically list security of processing as a duty. However, it does capture it in section 21(1), where it indicates that data controllers must comply with the data protection standards, one of which is the security standard. So remember, previously we had discussed the security standard and that data controllers must process data according to those standards. Well, security of processing, although listed in the GDPR as a specific duty for data controllers, is covered under this standard in the Jamaica Data Protection Act. So that is just an important thing to note. Now we can next look at the requirement to register with the regulatory authority. Now, under the Jamaica Data Protection Act, all data controllers are required to register with the Information Commissioner. This does not appear to be the case with the GDPR. However, the GDPR does allow for data controllers to be certified by their governing supervisory authority, and they are encouraged to do so, although certification is not mandatory. So this is an interesting one where under the Jamaica Data Protection Act, data controllers are required to register, but under the GDPR, it is not the same. We can next look at data protection by design and default. So this is an obligation for data controllers under the GDPR. So data controllers under the GDPR must ensure that any action undertaken involving the processing of personal data must be done with data protection and privacy in mind. So in other words, the controller must implement technical and organizational measures for ensuring that by default, only personal data which are necessary for each specific purpose of processing are being processed. So this is required under the GDPR, but specifically, whereas this is required under the GDPR, the JDPA does not specifically refer to this obligation. However, it would still be prudent for data controllers to adhere to it, as it is covered again under compliance with the data protection standards. So just as how security for processing was covered under the data protection standards, this too, data protection by design and default, would also be covered under those standards, although not specifically listed in the legislation as something that data controllers need to do. We can look at another obligation, which is the obligation for prior consultation. Now, data controllers under the GDPR are required to consult with the supervisor authority before processing, where a data protection impact assessment indicates that the processing would result in a higher risk in the absence of measures taken by the controller to mitigate that risk. Now, this obligation does not appear in the Jamaica Data Protection Act. However, it doesn't prevent data controllers from consulting with the Information Commissioner if they were to be in a similar position. So, although prior consultation is not an obligation under the Jamaica Data Protection Act, it would be a wise course of action to consult with the regulator in instances where data controllers are unsure about the risk, or if they're unsure about if the processing that they're engaging in would be of high risk. Another obligation that we can discuss is the obligation to do a data protection impact assessment. So we had discussed briefly earlier. We had mentioned it earlier about the requirement to do a data protection impact assessment. And of course, this requirement is found both in GDPR as well in the Jamaica Data Protection Act. So under the JDPA, which is Jamaica Data Protection Act, data controllers must produce a DPIA on a yearly basis, whereas the production of a DPIA under the GDPR is really dependent on whether the data was processed as described in Article 35.1. So there's a slight difference in when a data protection impact assessment should be produced, but both bodies of legislation call for one being produced. So these are some of the main obligations that I wanted to look at in this webinar. Of course, there are some other ones that we wouldn't really have the time to go into today, but as a segue from that comparative analysis that we just did, we can ask ourselves the question, well, how does the GDPR complement the Jamaica Data Protection Act anyways? And to answer that question, we have to really think about the fact that both the GDPA and the GDPR are founded on similar core principles for data processing, such as lawfulness, fairness, transparency, accuracy, integrity, confidentiality, and accountability. And the GDPR complements the Jamaica Data Protection Act by setting a very high standard for data privacy that Jamaican entities must meet when dealing with EU citizens' data, you know, that is also another thing to consider. We can also consider that the Jamaica data controllers can look to the GDPR and how it has been applied and interpreted to understand what to expect from local regulators. So much of the case law in the data protection space has come from the GDPR. So we can look to that case law to see how the legislation has been applied and interpreted. And just as how we could have used the definition of consent from the GDPR to translate in the Jamaica Data Protection Act, we can likewise use the GDPR to fill other gaps within our own legislation, and so both can work in tandem. So in essence, adherence to the GDPR can make Jamaica Data Protection Act compliance much easier for data controllers. So that's why it's worth really investing in GDPR training, because once you have that training, your training will be of a certain standard that allows you to not only be compliant with the GDPR, but also with the Jamaica Data Protection Act in most cases. Now, as it relates to that training, PECB really provides GDPR training, and they provide a curriculum with objectives that allows persons to really be adept to that training. Some of the objectives of their training course includes understanding the GDPR principles, which allows participants to gain a deep understanding of the fundamental principles of the GDPR, much deeper than what we discussed here today, including the principles, data protection principles, some of which we discussed, the legal basis for processing data, subjects' rights, and accountability requirements. Another objective of PECB's training is compliance requirements. So participants are able to learn about GDPR compliance requirements, such as data processing conditions, lawful processing, consent management, data minimization, data transfers, and data protection impact assessments. Some of these you've heard us discuss here today. Also, the training helps participants to learn about implementing data protection measures, which allows them to acquire knowledge about implementing technical and organizational measures to ensure data protection, including data security measures, privacy by design principles, and data breach response procedures. So these are policies and procedures internally within an organization that will allow persons to increase compliance. And as we discussed, you hear privacy by design principles. That is something that is required under the GDPR. Also, PECB's training allows participants to learn about managing data privacy risks. It teaches them to develop skills to identify, assess, and manage data privacy risks effectively, including conducting privacy impact assessments and developing risk mitigation strategies. Legal and regulatory framework. That is something that PECB's training course helps with as well. Participants will learn and understand the legal and regulatory framework of the GDPR, including the roles and responsibilities of data controllers, data processors, data protection officers, and the supervisory authorities. All very familiar based on what we discussed just now. Another thing that PECB's training course will assist with is GDPR compliance audits, which will see participants learning about conducting GDPR compliance audits, assessments, and reviews to evaluate and improve data protection practices within an organization. And these compliance audits are very important as they can assist companies to give the Information Commissioner information on their data processing when required to do so. PECB's training course will also help participants to learn about international data transfers, which is them learning about and exploring requirements and best practices for transferring personal data outside of the EU region, including mechanisms such as standard contractual clauses, binding corporate rules, and adequacy decisions. So these are some of the principles, or these are some of the objectives in the curriculum that PECB's training course offers. The rest of the curriculum is very detailed, very intense in terms of the content. You will learn GDPR foundation knowledge, which enables you to learn the basic elements to implement and manage a compliance framework with regard to the protection of personal data. And during this training course, you will be able to understand the fundamental privacy principles and become familiar with the role of the data protection officer. And the objectives of that training course is to understand the GDPR requirements and the fundamental principles of privacy, understand the obligations, roles, and responsibilities of the data protection officer, and understand the concepts, approaches, methods, and techniques to effectively participate in the implementation process of a compliance framework with regard to the protection of personal data. Another training course that PECB offers is the Certified Data Protection Officer training course. And that will help you to acquire the knowledge and skills to serve as a data protection officer so as to help organizations ensure compliance with the GDPR. So, this training course will be based on practical exercises, and you will be able to master the role of the DPO and become competent to inform, advise, and monitor compliance with the GDPR and cooperate with the supervisory authority, which will also be helpful with the Office of the Information Commissioner in Jamaica in terms of DPO training and doing the things that the legislation requires data protection officers to do in Jamaica. Some of the learning objectives of this course, of course, is to understand the concepts of the GDPR and interpret its requirements, understand the content and correlation between the GDPR and other regulatory frameworks, and to acquire the competence to perform the role and daily tasks of the data protection officer in an organization. You will also learn to develop the ability to inform, advise, and monitor compliance with the GDPR and cooperate with the supervisory authority. You will also learn strategic advantages of the GDPR for Jamaican entities, as it relates to global compliance. GDPR is really a comprehensive data protection regulation applicable not just to the EU, but also to organizations all around the world. So these trainings will really assist your organization to be compliant, not just with the GDPR, but with other international standards, including our own Jamaica Data Protection Act. It will give you a competitive edge, in demonstrating GDPR compliance, and you will have that competitive advantage in the global market, as many international clients, partners, and customers really prioritize working with organizations that adhere to strong data protection standards, giving compliant entities a favorable position, as I'm sure you know, in business negotiations and partnerships. So that is really an asset that you will gain by doing this course. You can also even think about the risk mitigation, as GDPR training really helps Jamaican entities understand and mitigate data protection risks quite effectively. And it does this by identifying potential areas of non-compliance, implementing robust data protection measures, and conducting regular audits and assessments. Organizations can really reduce the likelihood of regulatory fines and legal liabilities, as we had discussed under the Act. So it really assists with mitigating risk areas. Of course, another huge bonus is customer trust and the building of your reputation. By adhering to these GDPR principles, it really fosters trust and confidence among customers, clients, and other stakeholders. And really by respecting individuals' privacy rights and ensuring transparency, Jamaican entities can build a positive reputation for respecting data privacy, which of course inevitably can lead to increased customer loyalty and brand trust. So these are all benefits of um, engaging in the GDPR training. It really offers Jamaican entities strategic advantages, right, by enabling global compliance, enhancing data protection practices, gaining a competitive edge, building customer trust, mitigating risks, and fostering strategic partnerships in the international market. So these are some of the things that the GDPR training can offer to Jamaican entities, right? So with that, we have discussed the Jamaica Data Protection Act, key aspects of it in terms of the data protection standards, the rights of data subjects and the obligations of data controllers, and how those obligations relate to the rights of the data subjects. We've also briefly discussed the GDPR, some of its key aspects, some of the rights under it as it relates to data protection, data subjects, and some of the obligations under it as it relates to data controllers. And then we discussed how both frameworks or how both pieces of legislation interact with each other and how they compare. We did a comparative analysis, and we were able to see that the GDPR really adherence to it, or training under it, can really make compliance with the Jamaican Data Protection Act much easier. And so there's a real asset to understanding the legislation and how it works. With that, the presentation has come to an end. And if you have any questions, you're invited to send them to PECB, and they will have a response for you emailed to you. And so I want to thank you all for coming and for listening to the webinar. And I hope it was informative for you. And I hope you will reach out to PECB to ask more about their training courses, their GDPR training courses, and how it can really assist Jamaican entities